get to introduce myself. I don't get that chance often. Jennifer says I can just launch in. Is that all right with everybody? Okay, well, just do that. You hear me okay anyhow. I don't really need that so much. Well, thanks, very much for having me out. It has been, if I think it's been 5 years, it's been 10 that I've been here. That's the rule. If you think something's been a given amount of time, you have to double it. The last time I was here. Oh, sorry. Okay. Probably better? Is that better? Okay. I'll try not to get too close to that mic. Yeah, I worked on the oil and gas regs here, but that's been quite a while ago now since I was last year. Anyhow, I'm Jerry Dahl, and all I do is represent local governments, cities and counties. I do a fair amount of special counsel work for counties. At the moment, well, it's been a while now since I did the 1041 regulations. I see you have them. It was a denial, right, of a solar project. I saw that. 1041 denial, not that long ago. Well, maybe it'll come back in the right spot, right? But I have written a lot of 1041 regulations, both on water diversion for counties on the Arkansas River, but also for things like solar. And I did a group of those for El Paso County not that long ago. But for cities, I'm the city or town attorney for 4 different cities around the state, one of which is the town of Georgetown, which is the state's last remaining territorial charter town. Cities get their charters, right, from the statute, but before statehood, if you incorporated before 1876, you went to the territorial legislature to get permission to be a town. It's wholly separate and apart from our training tonight, just so you know, because it's completely different. But in order to amend a territorial charter for Georgetown, they run a bill in the General Assembly, believe it or not, instead of a local election. And it's one of the few bills every year where the General Assembly, you get bipartisan support and it passes without any no votes because they don't really know what they're voting on. But so it's fun to be the town attorney for Georgetown because they can do things a little differently. They're very proud of the fact that they're the last remaining territorial charter town. Well, let's go ahead. I promised that I would do an hour and get you done here so that there's a little break before your regular meeting. And you have an outline that I'd like to mostly follow. And my goal here is really just to reflect on some key tools, I think, and things to bear in mind as you carry forward your role as planning commission members. And I must begin by saying, thank you. Those of us that are staff, we love what we do, but we are paid. It is our job, and we're paid to do this, and you aren't. And you do it for the love of the community, even when the room fills up and they don't love what you're going to do. And you always send somebody out disappointed, and you do it for free. And I've spent my whole career being in meetings like this. It's all I have ever done. And I've just, throughout that 50 years worth of doing that now, I have remained really impressed by the volunteer spirit and the fact that all of you come and you do this work for free. And it's hard work, and you don't get thanked very often, so I am thanking you. And I really mean it. It is huge what you're able to do. So let's just get into the outline, and please feel free if there are questions as we go through. We'll keep an eye on the clock, and we'll get it done. Well, I start with the role of the commission. Most of this. It's the statute sets up what your role is, as does your code. And your code's pretty good on the role of the commission. I went through the zoning code and looked at that. You oversee the preparation and adoption of the comp plan. I know you're in the middle of redoing that now, and I think that's terrific. Comp plans are growing things. You have to keep, once you're done with it, 5 years later, it's time to revise it again. And that's just how comp plans are. So that's one of your jobs. The key job you have is you're the recommending body for zoning, subdivision, other land use applications. And that's the heavy lift that you do. And you're a recommending body, but that goes to the Board of County Commissioners, and you want to make your recommendations I think that ones that they'll listen to. They don't always take them. They're elected officials, and they've got a somewhat different job. And I think all planning commissions have to adjust to the fact or understand the fact that they're not the last stop, but you're an important stop. And the reason for that is, the Board of County Commissioners doesn't have the time that you do to look carefully and in depth at a land use application as against the land use code, because they've got other things on the agenda and other things to do. And so in a perfect world, they rely on your judgment. And I know it's appreciated. So there's that. But the scope of your review is really set by the code. Some of the commissions I've represented, some of the city councils I've represented have wanted to, fix an application that they'd like it to do this over here. Well, they're not the applicant, because they're not. You're the reviewing body, and it's the applicant that owns the property that gets to decide if they're going to apply for X number of new lots, whatever, or that zoning designation as opposed to a different one. And so we kind of have to remember, okay, where are our boundaries here? They've applied for rezoning from X to Y. That's what you review, despite the fact that you think they're wrong in doing that, and they really should have, been applying for a rezoning to something else. That's we assume they're adults and grown-ups. That's the choice they made, so that's what we review. Critically, your actions are reflected in the minutes of the meeting and what goes to the Board of Commissioners. In the end, you'll vote, and by a majority of a quorum, you'll make a recommendation of approval with conditions or denial. And I realize that sometimes you may not all agree on that, and some of you may vote against that motion. And you'll articulate why, and you're welcome to do that in the minutes of the meetings. And I've read about half a dozen sets of minutes of recent meetings of this commission. So I know that you're not shy, and I admire that. Too many times, the applicant comes and the public comes, and there's no discussion. And I'm really disappointed in that. Part of the reason we're here is to reflect, and it's your job as commissioners, I think, to dig into the application and say how you feel. But the point I'm taking too long to make is that you might be on the short end of a vote where you don't prevail. So let's say the commission's recommending approval, you'd like to recommend denial. You don't get a minority report. There's one action of the commission. It is the action that was passed by majority vote, because that is the rule in this country, and it's the rule in this commission. But certainly the statements you make on the record go into the minutes. The Board of County Commissioners gets that. That's all part of what they see. Most of what you do outside of the comp plan is actions on quasi-judicial matters, and I know you know this. I spoke with Lance earlier today, and I know that he's given training to you on this fact. So rezoning, subdivision, site plans, special use permits are all quasi-judicial matters. And that means you sit like judges. You don't wear robes, but you sit like judges, and you are charged with making a decision on something on the basis of what was presented to you in this room and in the packets that you got. If, for example, I want to sell a car to Jennifer, and it's a bad car, she thinks it is, she sues me, and let's say that Nicole is the judge in the case, everyone would agree, right, that it wouldn't be right for me to take Nicole out to lunch and bend her ear about the fact that Jennifer's wrong about that car. No, everyone knows that you don't talk to the judge outside of the trial. You just don't. The judge wouldn't allow it. The same is true for you as you act as judges. And that will be a theme that I'll mention as we go through the materials. So what's quasi-judicial mean? You sit as judges. So it's like a little trial, but it's a lot less formal. And it needs to be a lot less formal. But there are still some rules. You've got notice and hearing. People need to know that there will be a hearing or a trial on date, time, and place, and your staff does that. As the applicant, I got the right to present witnesses. I've got the right to legal argument. I'm pleased that in all the years I've done this, very seldom does an applicant or the opponents bring lawyers and we get into attempting cross-examination. I don't think that's that helpful. Sometimes they'll bring a lawyer or architect to articulate their case, and I'm fine with that. And usually it's someone that isn't all bent out of shape about needing to cross-examine. And so I've been able to avoid that. But they have that right, and importantly, they got the right to an impartial decision maker. So both Jennifer and I in that lawsuit have the right to Nicole being impartial in our case, and I'll touch on that in just a minute. One of the ways you can not be impartial is ex parte contacts, and I'm sure Lance talked to you about that. Contacts with the applicant, opponents, members of the public outside of the public hearing. That's why it would be wrong for me to take Nicole to lunch and bend her ear. The same thing's true for you in applications that you review. Once the staff has told you and once you know that the case is pending in front of you, the curtain goes down on your ability to talk to people outside of the hearing room. It's just the truth. I live in the real world. All the towns I represent, except for the city of Wheat Ridge, are little towns. And so I know that in the real world, in a small community, people talk to each other, and it's hard to avoid talking to people. And they may well want to bend your ear, and they're not trying to do anything wrong. They're trying to grab you in the grocery aisle, in the vegetable aisle at the store, at the post office, so they don't have to come here and spend a Tuesday night. And they do that innocently, and it's not pejorative. But it's on you to say no. That's all got to happen in the hearing. I'm sorry. And I have 4 ways that you can get out of a conversation that's ex parte. And the 4 ways I have, what are the 4 escape clauses are? The first one, you say, well, this is a quasi-judicial matter, and all the evidence has to take place in the hearing, and that might well just go right past them, right? Because it's just too complex. Door number 2, well, the county attorney advises that I not do this, and so that's a little more simple. Door number 3 is appeal to self-interest. Look, I can't listen to you because I might then have to step down and not participate in the hearing. The reason they're talking to you is they want you to participate. So door number 4 is, I think I have my wife's calling me, I've got to blow out of here. And sometimes that's the best door. So, I'm all about results, you'll notice. And whatever gets you out of that conversation is the thing to do, because then you haven't had the ex parte contact. I also live in the real world and realize that you don't know they're going to talk to you about this case until they talk to you about the case. It's a catch-22. So how do I avoid hearing something before I can tell them that my wife is trying to catch me? And that's fine, where you have short conversations. I'm not worried about that. I often will ask the commissions and the council members that I represent to mention that to me before the hearing. Then we can make a little record. And I've oftentimes done that, where you've kind of got trapped into a conversation and you couldn't get out of it politely for a little while, and I get that. We live, again, in the real world. And so I've done a little Q&A occasionally, and the staff can do this, a little Q&A that says, okay, I did, Jerry Dahl did speak with me about this outside of the hearing. I told him he needs to come to the hearing. He told me he is opposed to the application. I told him he should show up. Doesn't matter if he shows up or not. You've now told the rest, that's a good Band-Aid. I think you've put everyone on the same level. But if Jerry Dahl took you to lunch, that's more than you're going to be able to bring everybody in this room up to speed on, isn't it? And you're going to have to say, unfortunately, I had this long conversation. I'm going to have to step down and leave the room for this hearing. That's only happened a few times in my career, really, where that has had to be done. The main rule, of course, is try to get out of the ex parte contact. Mention it to staff if you feel you need to have a little bit of that record made, and make that record at the beginning of the hearing. Wire it with the chair. Hey, chair, open the hearing, and then let's do this little Q&A. And I do that regularly. It's all you need to do. But if the conversation is really short, I'm not concerned about that. And I don't think Lance would be concerned either. Well, that's what to do if it's occurred. On drive-by site visits, I've come to the position of recommending against them, even though I say they're fine, because of the potential to run into people, not literally, but figuratively. And then people are dying to tell you stuff, and I get that. I did what taught me about site visits and the fact that they weren't that helpful. I was the town attorney for the town of Silverthorne for about 20 years, and one of their developments, as they've grown north along the Blue River, those ranches turned into subdivisions. And the developer wanted to do a site visit to show us some site conditions. And so I said, okay, you'll send your engineer who will open the gates, and that's it, right? And they said, oh yes, we understand the rules. So I had a group of the commission there. And this engineer could not help himself. He just could, he said, well, this just for a matter of information, you know, the fence line is here and the land really drops away, and that's why we're moving most of the density this way. And I said, you know, I forget it, Graham, I think his name is Graham. I'm telling you, Graham, you can't do that. And he honestly, he just couldn't stop. And so I finally had to say, okay, the site visit's over. And it was a training tool for me, or a lesson for me. I just haven't gotten to the point where I allow those anymore because it's just too much risk. You get good information in the packets anymore. You get good aerial photographs. I also believe, you know, you live in this community, and I'm not upset if you drive by, but the goal here is not to bring information into the room that's different than everyone else, because you should all be at the same level in terms of the amount of information, the kind that you have to make a fair decision. Taking evidence, we've kind of covered this. Like judges, you shouldn't decide the case before the hearing the evidence. Again, real world, small community, the rezone comes in, you know who it is, what it is, where it is, and you also know, to be blunt, how you feel about it, because you do. You've read the application materials, but you haven't done the hearing yet. I had an occasion where a city council member, we opened the hearing, it's on a rezoning, the staff presents their staff presentation, and then it was the applicant's turn. Is that the order you do here, staff then applicant, or staff then applicant? So the staff, but the applicant's getting ready to stand up, and Commissioner, Council Member X says, well, I just want you to know I'm a no vote on this. And a fairly new council member who had run on kind of a campaign, you know, we think there's too much high-density rental housing in town. And good for him, he can have that in the campaign, but, you know, okay, we haven't even heard from the applicant yet. We haven't heard from the public yet. Talk about prejudgment, eh? And so I'm sitting there thinking, okay, what am I going to do with this? And there wasn't much I could do. I thought I could try to do a little Q&A, but that will just make it worse. You know, I can do a Q&A where someone's had an ex parte contact that wasn't, or a potential conflict and we need to make a record to say why their brother-in-law twice removed. As the applicant, it's still okay for them, you know, but that was one I couldn't really walk back. So just be aware of that. Obviously, no one here is going to do that. But what I have seen, and what's a little more invidious, is in the questions of the applicant, it's really obvious that it's not quite a when did you quit beating your dog kind of question, but it's really obvious that the person's made up their mind. And you may well have, but I would counsel you this, you're going to get the last word. You know, it's not like you've got to show this now because you might not get a chance later. You're absolutely going to get a chance. You're the ones that are going to vote. You're going to be able to elaborate at whatever length you want about why you do or do not support the application. So there's no reason to indicate that any earlier than the time when it's time for the commission to deliberate and vote. And again, it's fairness. People deserve a fair hearing, and they deserve the appearance of fairness. And I really, as you can tell, I believe strongly in it. It might be quaint, but I really do believe in giving people a fair hearing. And that's one of the ways that you can do that. I've indicated you don't attend and speak on the application at other meetings prior to the final decision of the body of which you're a member. Not contacting adjacent property owners or doing research ahead of time. I know that there's an inclination to do that, and I regularly have a commissioner, council members that want to do their homework and want to do more homework. The packets are already pretty thick, but I want to do more. And no, because then you have evidence in the record that's different than everyone else. The whole commission needs to have the same level of information. And the packets are thick, and you get a lot of material. And you rely on your staff to provide that information, but doing additional research means that you're bringing evidence that the rest of the board doesn't have, and the rest of the commission doesn't have. And that is one of the ways that you can have your decision unwound, because you're relying on evidence that's really outside of the record that was presented in the hearing. Conducting public hearings, I've looked at your rules of procedure, they're in the code, and they're really good on conducting public hearings, so I won't do a lot with this. But as I say, after 50 years, I've spent who knows how many thousand meetings I've gone to. I haven't done the math, but it's thousands. So I have real opinions about what's a good meeting and what isn't. But you can see what I've said. Announce the rules at the beginning. If there's a large number, divide the time. I think you allow 5 minutes here. 5 minutes is long, isn't it? It's really a long time when you actually get around to it. But you can suggest people not repeat prior testimony, but they are gonna. When I was younger, that bothered me. And it doesn't anymore, and here's how come. I sat in a hearing where it was clear that this one the person had practiced carefully their speech, in front of the bathroom mirror. And it was largely the same as the people in front of them. But what was more important than what they were saying was that they were saying it. And they're in front of you, and I want you to hear me say it. Yes, person X just said the same thing about too much density, or it's too, whatever they said. I'm saying the same thing, but I'm Jerry Dahl, and I want you to hear it. That's important to me, and it's fundamentally, just viscerally important to people. And I think those of us that sit on the other side of the dais, as you do, you go, okay, you're right, heard that already. Can we move on, please? And when I was younger, I was more impatient, and I've probably gotten more impatient about other things as I've grown older, but I've gotten a lot more patient about that, because I realized when I saw this person who was really worked up and intense about this, and I realized, how much effort she had put into putting this together. And that needs to be honored, I guess. And so you got to get the brass bottom award and just sit there, and take it, because that's, again, what you signed up for. It's just make sure everybody knows they've got the right to speak and give them their full attention. I was a lobbyist at CML for 6 years. I was their attorney for 6 years, and so I spent a lot of time in committee hearings. And there would be people that would drive in from Swink to testify, and it really upset me that sometimes their legislators would be sitting there reading the paper while their constituents had driven all the way in, again, to give a 3-minute speech, and they weren't being listened to. Yes, you've heard the speech before. Yes, you know what they're going to say. Yes, it's repetitious, but you should act as if you should actually listen to them and give them that respect. And you can tell I feel strongly about that. Over the years, I've felt that that's one place where we can do a better job. And it doesn't cost us anything to do that job. So testimony, what's admissible? It's quasi-judicial. So you're not going to get a lawyer in here saying that that's hearsay and can't be admitted. It's pretty relaxed rules of evidence. But you are allowed to consider, relevance. If somebody's saying they are reporting to you what somebody else has said, that's less, weighty to you, right, than if you got the actual person in front of you saying it. So you're able to do that. One thing I've made is consider all the testimony. Don't let the number of people for or against make the decision. That's hard because the room was fairly full. I could tell, I think, from the minutes on the solar project, and there were people, mostly, there were a lot of people opposed. And I'm reminded of the old game show, which now dates me. Remember the applausometer? Anybody remember the applausometer? You remember the applausometer? You do, okay. Where it's a game show. It's good you don't remember. But it's a game show, right? And they're contestants. And whichever contestant the audience applauded for most loudly got the washing machine or whatever. And there was a little meter that would, because it was hooked up audio, and so that's who got the washing. I'm going to have to update this analogy. Is it time for me to update it? Fine, I'll go with likes, I guess. Whoever got the most likes. But yeah, but you're not an applausometer, right? If you were, we wouldn't, all we would need would be the applausometer. We wouldn't need you, right? It takes courage, I realize, to say yes to an application where the room's full of people saying you should say no, or the reverse. And sometimes that's your job, and that's hard. But remember all the people that aren't in the room, because you're representing them too. And that, I think, gives you comfort when you've got to make a decision that might be uncomfortable for the people that showed up.
Can I ask you a question?
You bet.
On the topic of what testimony is admissible? When we're listening during like a public comment, for example, we're all hearing it at the same time. Sometimes people will come to give public comment and they'll have like a piece of paper that has stuff that they've written on it. And they want us to all have a copy of it, to look at it. What's your opinion on whether or not we should be looking at stuff that's brought to the podium to distribute to us?
Yeah. I take the position that if they've made the copies and it's a public hearing, they're allowed to hand them out. You know, that's fine. If they didn't bring enough copies, that's too bad. It's not your job to do that. For people that I think they're not quite sure what are the rules. If I bring this, it should be good enough, kind of thing. I've seen the chair does usually a good job, or it's the job of the chair to say, please give that to the staff. Thank you. We'll make sure that's part of the record. And I think that's a kind of a polite and dignified way of accepting something that's pretty hard for you to act all of you, okay, we're going to pass it down, we're all going to have to read it. You know, if I as a witness, if I really want you to see that, I show up, I give it to the staff right away, it gets handed down, and it can be being passed out while I'm talking. But not everyone, you know, spends their time being lawyering. So whatever people bring, it's fair to receive it. It's not inadmissible. It's just not particularly weighty or relevant if it's not fashioned in a way that you can easily absorb all of you in the hearing.
Right, and I know I advise folks if they have stuff that they want to share with us to try to submit that in writing in advance so that it can be a part of our packet.
Absolutely.
But I know sometimes when we've talked about this in the past, the rule of thumb has been don't pass it out to us and we're going to give it to the staff, but oftentimes we don't see what's given to the staff.
Yeah.
So while it might be a record like for the actual commissioners, it's not really a record that we get an opportunity to review as we're making a recommendation.
Yeah, I hear that, and the problem is it's not your job to sort of solve the problem that this one witness has created, you know, by bringing something that isn't really accessible to all of you. You know, so what are our choices? There's usually three, you know, I suppose. Stop and wait while everyone reads it, which I think is doing too much for the witness. That's solving a problem they've created. Urging them to, as you say, give that to the staff ahead of time and we'll make sure we have it. Or it's the least useful, but at least to preserve dignity. Thank you very much for the inch-thick, you know, thing. Please give that to the staff. We'll make that a part of the record because it's impossible to use that document in any reasonable way. So short of saying, I'm sorry, we're not going to accept that, it's too much, you know, then as you can see, I'm very interested in trying to preserve dignity for people, trying to accommodate what they're trying to do, even when they're putting it in a way that's just not that useful. That gives you 2 or 3 different tools, and you kind of take it case by case. It sort of depends upon what it is. If it's one sheet, maybe it can be passed down. We'll be reviewing this as we take additional testimony, or, you know, however you want to try to handle that. But it's a problem not of your making, so you have to kind of decide how to do 2 things. Give reasonable weight to it. Give it the weight it deserves based upon kind of how it's configured, but not let it stand in the way of the work of the commission in conducting a reasonable hearing, because that has one person holding the hearing hostage. That's not okay. Yep, you bet. So taking action, we're down to let's see, we talked about the applausometer, but now everyone will remember the applausometer. That's great. So the applicant has the right to make a full presentation, present multiple witnesses, and to respond after the public comment closes. I notice your procedures allow for that, and I'm glad they do. The public sometimes is upset that the applicant's getting 2 bites at the apple, right? And occasionally you get people say, well, how, if they get to present again and kind of rebut what we, the public, said, we should be able to stand up again. And no, they're the applicant, and they really carry the burden of proof. They've got the right to be able to make some statements after the public comment period. And I see that it's in your proceedings, and it's how you have proceeded, and I think that's good. Taking action. Well, you've got a record that you make when you receive all this evidence, and you have to draw your conclusions from the evidence in the record made at the hearing, not any outside research. That's important because think about it, judges don't go interview witnesses outside of the hearing ever, right? Do they? They just don't. They listen to whatever evidence was presented in the hearing. In addition to that, you base your evidence on whether it complies with the code, not whether as a commissioner you think it's a good idea for this property to be rezoned. If you think it's not a good idea, there may well be, and there probably are, reasons in the code or bases in the code for you to say it's not a good idea. But just saying, well, I don't support this, per the commissioner I was talking about earlier, there's plenty of ammo for you. You know, if the idea is that you want to oppose it, there's plenty of reasons to, other than just saying you don't like it. So always find a code basis, and usually the staff report will give you that. The applicant is in charge of their application, as I mentioned earlier, and I have had commissioners try to kind of redesign the application on the spot with conditions that effectively make them the applicant. And this is one of those sliding scales, isn't it? Because occasionally, you know, you can have a condition that says, you know, I think the setback from the county road needs to be 10 feet more. That's a recommended condition because of the presence of underground utilities, whatever, county maintenance, whatever. You know, okay, pretty minor, but now the setback's here, and this building would be better if it faced this way, and now you're redesigning the application. It might be better, but you're not the applicant. You know, the applicant is. They are grown-ups. They decided that's what they wanted. And rather than saying, okay, do this, and do that, that may well be recommendation of denial. You know, at some point, you're not in charge of making the application fit the code. You're in charge of reviewing
I have a question. At what point do you think the conditions become too burdensome that you've now crossed the line and now you're changing the application?
You're asking the good questions because they're the ones that are on the gray, in the gray zone. You know, the black and white ones are easy. At what point is it too burdensome? Clearly, where the conditions would make the, I think, make the project impossible because they've designed it to fit with the code, more or less, we assume. I'm not answering that question very well. Well, when they turn the project into something that's different from what the applicant is asking for. Again, not doing very well with this. I can easily tell you, here's what falls on this side of the line, and here's what falls clearly on that side of the line, and you're asking, okay, well, where's that line exactly? And I can't tell you without being in the room for that application, but you'll see that my tendency and my trend here and my inclination is to say conditions that redesign aren't okay, you know, because then if the condition is you being the applicant and saying it would be a better application if it did this, not your job, not your job. The application, we need this condition because we really need to protect this adjacent neighborhood, and the screening isn't up to it, and that's one of the tools, one of the conditions that we can apply, and then fine. I'm sorry that I can't do better than that because it's hard to without a hard case, but you see my basic inclination is you don't get to redesign. And when you start thinking like you were the applicant, should be a red flag to you.
Thank you.
You bet.
If I could follow up, how
Yep.
do you feel about conditions of approval that may put an additional financial burden? And an example of that would be, we put a condition in there that the applicant must drill a well to, like, the deepest aquifer, for example.
Yep. Is there a code basis for that condition to begin with? Because there needs to be. Conditions need to have a code basis, because otherwise you are kind of just deciding to be the applicant.
Okay.
You ask, but let me use your question to answer one that I think I would like to be able to, which is that, applicants don't have the right to the highest and best use of land, right? And you will often hear that, well, this is going to deny me this use, and you can't do that. Well, absolutely you can. That's what zoning does, really. And I think that I make that point elsewhere, and this gives me the chance to make it here. But my answer is, I'm not worried that a condition costs money. Fine, lots of conditions do, and zoning costs you money, it just does, and that's fine. But what would concern me is, okay, where in the code is the standard applicable to this kind of land use application that well depths are relevant? And if they aren't, you're coloring outside of those code lines. And I would say no to that conditions for that reason, but not for the financial reason.
Okay.
Is my take.
Thank you.
Thanks, Ed. Let me answer two questions at once. I appreciate it very much. Let's see here. One thing I do want to point out, in looking at the minutes from the last, half dozen meetings, there's a fair amount of fixing kind of minor things in applications. And yeah, applicants run a wide gamut, don't they, in terms of professionalism, right? There's an application I might write, giving myself a credit, I suppose, or bragging, probably fruitlessly. But I probably could write a pretty good application, right? And I'd check it for typos, and I'd make sure everything was correct. And then there's the applicant that doesn't have professional assistance, and there's more, there's more stuff in there. I'm a real eye on the prize guy, though. And the prize here, in my opinion, is that you're a recommending body. You'd like to have impact, right? You'd like to not have whatever you do in this room be ignored by the Board of County Commissioners. Because, that's the prize for you. If you're recommending denial, you would like them to go with that. If you're recommending approval with conditions, you like them to go with the conditions you put together. They're your audience, and that's who you got to convince. And I'd spend my time on that, and I would not worry as much about the minor errors in an application, because that is not going to get approval, denial, or approval with conditions out of Board of County Commissioners. That is not going to be the reason they're going to go with whatever they're going to go with. That is not going to be the reason that your decision's upheld or overturned. It's going to be how solid were your reasons for what you did. That's where I'd spend my time. And I absolutely get the temptation. We've seen all these applications, and we're good at finding these errors, and we're good at making corrections. We'd like things to be good and correct. But it's not the best use of our time. And I'm especially concerned because over the years, I've heard resentment from commissioners, planning commissioners, that the city council, the board, doesn't go with their recommendation. And that's really frustrating to them. And I absolutely get it. You spend all this time, and the board, which for reasons you think might not be as solid as yours, went with did not follow your recommendation. You don't want them to be distracted, right, with anything but what you're trying to get across the table to them. That's why I would spend less time on that. I get it that There'll be some errors in the application. That might happen, but that's not what is going to make a difference at the commissioner level, and you want to make a difference. That's my take. Now, I realize I'm the guy who drove in from 100 miles away, and probably will put my foot in at least once here in this 1 hour that I've got with you. And if I'm not doing my job if I don't put my foot in it once. Hopefully I'm not there, but I will tell you I did notice that. And I think that again, if your goal is to be recognized and followed as this goes up to the commissioners, I'd really spend more time on that. Or that's where I'd spend my time. The budget of time that you have is where I'd spend it. Should we talk about amendments to motions and that sort of thing? You've got good policies on those.
Can I ask you a quick question before you move on? Because I saw under taking action, you had the one talking point about referral comments, like from the fire, sheriff, traffic, that they're part of the record and can be relied on for conditions of approval. Just wanted to ask, in your opinion and based on your experience, how much weight should be given to referral comments, particularly when there's an applicant that, in a referral agency's opinion, has come up short, and they want the county to know that they're not happy with how negotiations have gone or what the result is of their time in talking to the applicant.
They, the referral agency?
Yeah.
You missed me with the pronouns. I wasn't sure who.
Yes, they being the referral agency saying, we have problems, and I think we've had applications in the past where that's had a lot of weight, and it's been a factor why we've denied applications. So just wanted to hear what your thoughts were on how much weight should be given to these referral comments.
I'd give them weight where there are code standards that those referral comments are really pretty relevant to. And because we have so many referral agencies, I'm doing a piece of work right now for Routt County, and they're reviewing a major development, and they've got a lot of referral comments. But, some are marginal. They're important to the referral agency, don't get me wrong. Whatever's in your wheelhouse is the most important thing, it should be. But they really aren't that relevant to the county's land use application on that, for that purpose. So I think I'd look, again, it's a matter of weight. I think I said elsewhere that you get to decide how much weight to give. Your question's exactly on that point, because not all referral comments are equal. So
as much as they're tied to the criteria that you are
exactly
reviewing.
Right. Yep. And then that's great. If they're tied to the criteria, they can be really helpful in a denial or a condition based upon the criteria. I think this criteria is not being met, as evidenced by referral agency X, Y, and Z on that point. That's really compelling. But where you've got a referral agency that feels like they really should have gotten more right-of-way dedicated for dry utility, for it's Excel or somebody that, I can always dump on Excel, but, that really just wanted more. But it's not that relevant to a review criteria. I would give them less weight. And I think I'm glad you asked the question, because the home there, and I never really thought about this, but the home is, okay, how does that relate to our job as commissioners and our code? And sometimes they really relate directly, and sometimes they, while of interest, they're not, they're just not central.
Okay, thank you.
You bet. Motions, your policies do a good job with motions and sort of what happens when there's a tie vote. I'm impressed it says keep trying, but if you still don't get an answer, it's a denial, which is good. I was in a commission meeting once where they had no policy on that. The case law is that a tie vote means no action, but you have done better with that in your policies. It says tie votes, if they persist, mean a denial, and so that's fine. On conditions, the point I'm making here, it's the bottom of that page 3, I guess, is something I've taken from my time at the State House. And the state legislature, for all their ills and not listening to their constituents and reading the newspaper, they do one thing really well. They do many things well, but one thing the committees do really well is organize conditions on bills. And where you've got several conditions that might want to be approved. but you've got different commissioners that are interested in different conditions, right? So you're a little worried that if you do a motion with all of them, you're not going to get everybody voting. So how do you do that? The State House committee chairs are really good at this. When they've taken all the testimony, they'll ask the bill sponsor to put the bill on the table, and somebody will make a motion to approve the bill, right, just as presented. But then the chair will say, I'm going to ask for a motion to approve the bill, and then we'll take motions to amend. And so they will take individual motions on individual issues to amend. It's like, okay, the bill is the Christmas tree. Now we're going to take motions on which ornaments we hang on. That way the whole commission can vote on the First Amendment. If it's approved, great, it goes on. If it's denied, no. And you can run yourself through a series of amendments that way, and everybody gets kind of a fair shot. And you don't feel as if you've got to vote against or for the package because you don't like a piece of the package. And that's a way to make it fair. And in the end, everybody votes, and you've gotten yourself through that series of conditions. Much of the time, you won't need that tool because the three conditions are going to be what they are. Everybody's cool with voting on them as a package. But if you find yourself running into trouble with someone saying, well, I'm for this, but not that, and how do I vote? I'm forced to vote against because that's how you navigate that. And the state legislature, of course, they're good at some things, and that's one thing they're really good at. So that's a tool, that's a trick you can use, and feel free to use it. Let's look at a few of the other things here. I'm top of page 4. I've kind of covered, stick to the request before you. You apply the same standards of relevance to your comments and decision you want to see in public testimony. You want the public to be focused on this application and the standards applicable to it, and you should apply that, to yourselves. They're in charge of their application at the request of rezoning to CT. I have no idea what CT is. It's probably a zoning district somewhere. Sorry, but that's what you vote on. Grounds for denial. We've kind of talked about this. In the applicable portions of the code, always find a home base in the code for either a ground of denial or a condition, because you're held to that. You don't get to write other stuff into the code that isn't there. If something should be in the code, you make a note of that. And we amend the codes all the time, and that can be added. Codes are living things. I'm constantly updating the codes for the communities I represent. I've got grounds for denial, proper and improper. Applicable portions of the code, yes. Grounds for denial, failure to develop or not to volunteer a condition which couldn't be independently imposed. That was the condition, the business about the well that we just talked about. Talk about failed motions. Land use regulatory tools. I do want to make a couple of points about them. And I'm going straight to the comp plan. It's not regulatory, right? That's the case I note there. I'm sadly old enough to have been one of the attorneys on that case in 1982. And in Summit County, if you go to the very top of Dillon Reservoir, the Blue River goes into Dillon Reservoir, that's Farmers Corners is what that is. And in the 80s, there was nothing there but a gas station and a bar, I think. And the sewer treatment plant for Breckenridge was there. The sewer outfall was there, little known fact. The Theobalds owned a whole mess of ground around that area, and the county adopted a comp plan that had growth centers identified, and they had not identified Farmers Corners in 1982 as a growth center. And the Theobalds got really upset that they were downzoned because they were not shown as, because the Theobalds had their eye on greater things, wanted to develop Farmers Corners, which happened, by the way, and you drive through there now, and there's a whole lot going on. So they ended up doing just fine, but they sued the county saying, well, you've downzoned us by virtue of saying in the comp plan that we're not a growth center. Colorado Supreme Court said, you brought the lawsuit way too early. Comp plan is just a guide. It is not zoning. You have to wait until the zoning actually says yes or no, and then you can challenge that. Your comp plan has sort of a generalized language about consistency, and when you do rezoning or whatever applications. And I talked with Jennifer about this earlier. I know that it's always a tough thing with a comp plan, because comp plans have a lot of kind of should, shall, should a kind of encouraging language, which is very different than a zoning code, which has you shall do this and you shall not do that. And I'm often asked, well, can we deny this application on the basis of inconsistency with the comp plan? And my stock answer, and it still is, find an additional reason. That should not be the only one where you have a comp plan that is not adopted as a regulation and that doesn't have that specific yes-no language in it.
Can I ask you a question? I know for us in particular, the consistency with the comprehensive plan usually is a criteria for our land use applications. So I think what I hear you saying is even if it's cited as a criteria, you think it's still best practice to have another criteria that you think fails.
Absolutely.
If you're going to,
yep.
Okay.
Absolutely, because now I'm putting on my county attorney hat, right? The thing gets denied just on the basis of the comp plan only, and now I'm in front of the district court judge. And I want to have that and, Your Honor, see it is inconsistent with section XYZ of the zoning code. And the commission and the Board of County Commissioners also noted that in their findings of denial, Your Honor, and then I'm good to go. But if it's just the comp plan, I'm still making the case. Don't get me wrong. I'm your person there. I'm the county attorney. I'm defending the action. But I need that help. Thank you. Let's see. I'm on page 5. Zoning, we've done that. Subdivision, plan new development. One point I want to make about both rezonings and uses by special review here, and again, rely on your county attorney. If it's any different than if he says anything different than what I'm saying, you got to go with him because he's your guy. I don't want to make a bed that he has to lie in, right? In the end, it's him. But my review, this often comes up on special use, on variances, and on rezonings. Well, you've got this list of criteria. If they haven't satisfied them all, we say no, right? That's not the language of the code. I've got the code right here, and it says review criteria. This is for rezoning. The following criteria shall be considered by the Planning Commission and Board of County Commissioners in reviewing all rezoning applications. Does not say all of these criteria must be satisfied, because some, frankly, may not apply on a given application. So you look at those criteria, and the lead-in language is key, and the way the code is written is key. And there are many codes that say the following conditions must be satisfied. Then you're right. Then it's the list. You got to get them all. I often see this in variance territory, where old land use codes used to say, and you don't review variances, do you? You do not. That's Board of Adjustment, all right? Right. But nevertheless, it often comes up there where it's hardship, right? Hardship, self-imposed, et cetera, and maybe 3 of them clearly are there, but 1 isn't. But you still want to say yes to the variance because it really is deserved.
Can I ask you a question?
Yeah.
Do you think that is a result of poor drafting?
Yeah.
Or, because that would be a question too, did they actually mean to say that there was, that all of these criteria should be met, or that just some of them needed to be met? So how do you know if it's poor drafting or intentional?
Yeah, I think it's poor drafting, and I think it's a style that was, put it this way, drafting without realizing the effect, I guess, rather than, but it's the same, because so many times the Board of Adjustment would go, this is really a hardship. We really ought to be saying yes to this, but there's this not self-imposed, and they bought this property knowing that the setback didn't work for this house, and so how can we say yes? And since that time, since I saw that, I've been trying to when I get the chance to redraft codes, I always say, in consideration of the following criteria, releasing you from the stricture of having to pretend sometimes that a condition has been satisfied when it just hasn't, and frankly isn't that applicable. And I will say this, for the codes that I've had to rewrite with that in consideration of language, similar to what you have here for both rezoning and special use, that hasn't been abused. I haven't seen applications get approved where the majority of the conditions weren't satisfied, but it has released the reviewing body from having to sort of pretend that condition 7 or whichever, that really is kind of irrelevant or not useful here, has been somehow been satisfied, and they twist themselves into knots trying to justify it. Happily, I think you've got reasonable language, but your question's a good one. Is that bad drafting? I think we all got in a habit of the following conditions, and that works in a lot of cases, but it doesn't work for rezonings, for special use, and for variances that well. That's my take. So let's see here. Exactions, conditions of approval. I'll finish with that. We got like 4 minutes, and then we'll talk briefly about conflicts of interest. I know that Lance has probably covered this. We've got these two cases. We have Nolan versus California Coastal Commission, right? That stands for the proposition that there has to be a reasonable relationship between whatever condition you're going to impose or exaction and your government goal. The Nolans, you've heard the story, right? They had owned this little kind of bungalow on the beach. They wanted to scrape it and build the big bungalow on the beach. California Coastal Commission runs everything within 600 feet, I think, of high water line, and said, well, we're going to require that as a condition or an exaction, you provide additional access parallel to the water, because our concern here is that when you're on Highway 1, you can't get to the water because there's this line of houses that blocks people from getting to the water. Well, how exactly does a condition right away along the water get people to the water from Highway 1? It doesn't, right? There's no reasonable relationship between, there's no reasonable relationship between the exaction and the alleged government interest here. If they'd said provide a pull-off parking up on the highway, well, maybe, but so that's one standard. And then there's the rough proportionality standard, the Dolan standard. Florence Dolan owned the Highboy plumbing supply. Everyone probably has heard this already, but I'm telling you again. She owned a plumbing supply store in Tigard, Oregon, and wanted to expand. The city really, they said, okay, that's additional impervious cover, and so what we want is for you to provide a dedication of and more people will be coming to the store, so we want you to provide additional trail behind the store where there's a creek, and we want you to dedicate that to us. And the issue is, well, that's not really roughly proportional to the, how many people go to the plumbing supply store on bicycles. It's not really that proportionate to the impact you're trying to solve. So we take those two, you got to have a government reason for the thing that you're asking for, and the thing you're asking for has to serve that government purpose. That's Nolan. And it has to be reasonably related to the level of impact. And we see it more often in, say, parking or size of parking, or if you're expanding the parking lot twice, how much drainage and detention do you need? There you could dial it up or down, and that's your rough proportional rule. I've given you some acceptable conditions and some ones that I think are not permitted. You'll notice the acceptable conditions, again, things that support the enforcement of the requirements of the code. You won't be surprised by conditions which aren't permitted. Density restrictions of what you're doing in a site plan, conditions that don't have a code basis, we talked about that, conditions that redesign the application. So I kind of intentionally am repeating myself there. Ending with conflicts of interest. You've got good standards of those in your code as well. What to remember is, as Deep Throat said to Robert Redford in the parking garage in All the President's Men, follow the money. Remember, he said that? Do I have to update that one too? Okay, in any event, when people say, well, do I have a conflict here? The real key in Colorado law is, and I actually, when I was at the legislature for CML, I worked on the conflicts of interest statute that is now in place. And it really is keyed to money. If you have the potential to gain or lose, and including lose money as a result of the net of the application, that's a red flag. In addition to that, close family relationships, father, mother, brother, sister, wife, spouse, but where you get a little further out, the real key here is is those would say no. But what must you do about a conflict? Disclose it, step down, don't vote, and that's what your code says. The city of Steamboat Springs, for years, the mayor worked for the ski area, and about every third thing that was on the agenda in Steamboat was having to do with the ski area. So when they get to that agenda item, everyone would look at the mayor and say, okay, I know. And he'd get up and he'd go and he'd leave the room. And nobody ever in Steamboat ever said, well, I think the mayor probably improperly influenced. He was not in the room. So, I've had council members actually say, well, can I just sit in the front row and make faces? Can I stay on the dais but just be quiet? And none of those are appropriate workarounds. Happily, your code is really pretty clear about that if you've got a conflict. I tell all of the electeds and appointeds that I represent, if you're concerned about whether you do or not have one, call me. That's what the county attorney's for. That's what the city attorney's for. You should call ahead of time. And we attorneys are delighted to get those calls before the meeting. So much better than if we get them in the meeting. And it's got to be in the meeting, it's got to be. But I can then do a little Q&A, and I've done that many times. Hello, Councilmember so-and-so, you've informed me that your wife's father used to work for Excel, or that you have 3 shares of stock in Excel. Is that right? Yes. Excel's got an application in front of you. Is that right? Do you believe you'll be able to render an impartial decision despite the fact that you own 3 shares of Excel stock, or where it's a de minimis conflict? And they will say yes, and then I'll say, we've made a record that enables you to participate. But the attorney can really help you either make the record for why you can participate, or make the record for why actually you shouldn't, and it's okay that you can leave. And that you should rely on us for that. And knowing that ahead of time, sending an email to staff saying, I've got this question, can the county attorney address it? I know Lance will respond to that. I promised you I'd do an hour and 3 minutes, but we've got a couple minutes, but I know you've got a hearing coming up in about 12 minutes. But I want you to know how much I enjoy, you can tell, I like doing this. And I really appreciate your willingness to, as I said at the beginning, volunteer your time to do this in these rooms. It's huge that you do that. So thanks for having me. And try to get home before it snows. Okay. All right.